Namaskar, I am Advocate Saurabh Kunal. Welcome to my channel. Here we discuss issues of legal and financial education. So today the topic is what are the administrative and legal remedies to a person whose complaint has not been registered by the police official. Yes, many times when a person visits a police station with a complaint, his complaint is not registered in the first information report, and so what legal and administrative remedies he has. So before starting the topic, let me read the abstract of the landmark judgment pronounced by the Supreme Court Honorable Supreme Court in the year 2008, and the judgment is Latika Kumari versus State of UP. In this judgment, it was held that registration of first information report is mandatory under section 154 of the Code of Criminal Procedure if the information discloses commission of a cognizable offense, and no preliminary inquiry is permissible in such situation. It means it is mandatory, particularly in the cases where cognizable offenses has occurred and no preliminary inquiry can be is permissible. In those situations, it is required to register the FIR. However, and let me tell you that the Supreme Court, the Honorable Supreme Court, has also issued guidelines to all the police official to register the FIR, and a guideline is there by the Honorable Supreme Court. However, despite of the fact, many times when a person visits with a genuine complaint, he could not register his FIR. So what are the administrative and legal remedies he has? First of all, we will discuss about the administrative remedies. If a person went to a police station and his FIR has not been registered by the SHO of the concerned police station, then he can move to the superintendent of police, and he can write an application under 154(3) of the Code of Criminal Procedure with prayer to the superintendent of police to direct the SHO of the concerned police station to register his FIR. In case if the police SHO as well as the superintendent of police do not give any heed to the complainant regarding his complaint, then the complainant has judicial remedies also. So what are the judicial remedies? We will discuss it, but before that I will try to discuss another Supreme Court judgment that will give more light on the situation. In Sakiri Vasu versus State of UP, it was held that if a person has any grievance that the police is not registering an FIR, then he can approach the superintendent of police under section 154(3) with a written application. Even if that does not yield a satisfactory result in a way that either FIR is not registered or proper investigation is not conducted, it is open to the aggrieved to approach the magistrate under 156(3) of the CRPC. Now the Sakri Vasu versus State of UP, the Honorable Supreme Court has cleared the way that 156 is the appropriate way. If the complainant is disappointed by the SHO or the superintendent of police, he can approach the magistrate with a written petition under section 156(3) of the CRPC. Now, what is section 156(3) of the CRPC? We will discuss. Section 153(6) of the CRPC says power of the magistrate to order investigation. Just one line. Power of the magistrate to order investigation. Power of the magistrate under section 190 to order investigation. Now this is a one line. The 156(3) is simply one line, and this gives enormous power to the magistrate to order for investigation. Now, what are the prerequisites? This case has also given some conditions on what conditions, after exhausting those options, you can approach. First, you have to write a complaint to the concerned SHO. Then you have to write an application to the superintendent of police. If a person is dissatisfied at both the places, then only after exhausting these two options, then only the third option is to file a petition under section 156(3) of the Code of Criminal Procedure. So this is the first option. So for filing a petition, these two options need to be exhausted. Now, how to draft a petition? So for drafting a petition, you can simply start by putting the name of the magistrate, or simply by putting it in the court of chief judicial magistrate, and then the district, and then the name and address of the petitioner. After petitioner, you have to give the name and address of the accused. In case if the case, for example, if the case has two accused, then you have to give the name of the first accused as defendant number 1 and the name of the second accused as defendant number 2. Now you have to also imprint the SHO of the concerned police station as defendant number 3. Now there is a question, what is the need to imprint the concerned SHO as defendant number 3? Yes, there is a need, because in the prayer of 156 you will ask the Honorable Court to direct the defendant number 3 to register an FIR under such and such sections of the IPC. So that is very much essential to imprint him as a party. Now for that you have to also after the defendants, you have to write application under section 156(3) of the CRPC to register an FIR under such and such section of the IPC. Now after that you have to give the prosecution story, the real you have to give all the facts and circumstances, in what facts, under what circumstances the offense occurred. Now after writing that, you have to also mention that you approach the concerned SHO for lodging the FIR. However, the SHO did not give any heed. So you went to the superintendent of police and you also filed an application under section 154(3) of the CRPC. However, the superintendent of police also didn't give any heed. After that, means you have to give two complaint, a copy of both the complaints, and it is better. It's my personal advice that you should also register or speed post the complaint, and you should also annex the receipt of the speed post or the registered mail with the petition. It will satisfy the court that you have exhausted both the options. Now after this you have to pray. Now what are the options before the magistrate? The London magistrate will have two options. First, after going through the petition and after the arguments, the magistrate can directly order for an investigation under section 153(6) of the CRPC. He has one other option also, an alternative is there, that he can take cognizance under 190 of the CRPC and call the witnesses in the witness box for examination of the witnesses. And after taking all the examination, if he satisfies, he can order for an direct the SHO, concerned SHO, for registering the FIR. Now in the pre-cognizance stage and in the post-cognizance stage, there is a one catch. Catch is that in case if the London magistrate has taken cognizance under 190 and he took the an examination of the witnesses under 200, then there is a chance that he may treat the complaint under section 156(3) as a complaint under 200 as a private complaint. Now what is the difference between 156(3) and 200? Even though I will deal it separately, I will make a separate video on 200, but broadly there is a difference that 156(3) is majorly for the cognizable offense and 200 is for minor offenses or petty crimes or crimes of civil nature. So that is the difference. Another very crucial thing is, if a complaint is filed under section 156 and it is treated as private complaint, then the onus to present all the documents, all the witness, all the evidences before the court lies on the petitioner. At times the petitioner has limitation because if a police took the investigation through interrogation, he can collect lots of evidences and documents to present before the court and make your case stronger. So that is the difference between 156(3) and 200. So it is preferable that you must file a complaint under 156 and persist that you should get an investigation under 156(3). Now in case your 156(3) is dismissed, what options you have? You have the option to go for revision under section 397 and 401 of the CRPC. And I have made one specific video on that, and I will give you the link in the of the video in the description. Now revision is open before you. Now there is another option. You can move to the High Court also. In the High Court, under section 482 Code of Criminal Procedure, there is a subsection to secure the ends of justice, and in that you can file an application before the Honorable High Court to direct the SHO, concerned SHO, for registering the FIR. You have another option. You can go under the writ under 226 Article 226 of the Constitution of India and request the pray before the Honorable Court to direct the concerned SHO for registering your complaint. So this is a writ, but I will give you my personal advice is to go for 482 of the Code of Criminal Procedure instead of 226 Article 226 of the Constitution of India, because once your article is dismissed by the court, you won't have any other remedy. So that is about the options after dismissal of the 156(3) petition. So these are the two options. You can either go to the district court or district and session court, or you can move to the High Court for under 482 or writ. So these are the options. So this is all about 156(3). So I will be making another video on 200. So those who are new on my channel, I request all of you to please subscribe my channel to get the latest updates on the legal and financial issues. So this is all about 156(3). If you like my video, please like, share, and please give me your feedback in the comment box. And thank you so much for watching this video. Thank you. Namaskar.